The Constitution of the Netherlands is one of two fundamental documents governing the Kingdom of the Netherlands as well as the fundamental law of the European territory of the Kingdom of the Netherlands. The present constitution is generally seen as directly derived from the one issued in 1815, constituting a constitutional monarchy. A revision in 1848 instituted a system of parliamentary democracy. In 1983 a major revision of the constitution was undertaken in which the text of the constitution was modernized and new civil rights were added, along with a number of other changes. The text is very sober, devoid of legal or political doctrine. It includes a Bill of Rights. The Constitution prohibits the judiciary to test laws and treaties against the Constitution, as this is considered a prerogative of the legislature. Thus there is no constitutional court in the Netherlands. The Kingdom of the Netherlands also includes Aruba, Curaçao and Sint Maarten. There is an overarching constitution of the entire kingdom, the Statute of the Kingdom of the Netherlands. History. The first constitution of the Netherlands as a whole, in the sense of a fundamental law which applied to all its provinces and cities, is the 1579 Constitution, which established the Confederal Republic of the Seven United Provinces. The constitution was empowered by the Union of Utrecht, thus by treaty. Article 13 of the treaty granted each inhabitant of the Republic freedom of conscience. The Union of Utrecht Treaty inspired the American Articles of Confederation. After the French invasion of 1794, the Batavian Republic, a unitary state, was proclaimed. On the 31st of January 1795 it issued a Bill of Rights, the Verklaring der Rechten van den Mens en van den Burger. On the 1st of May 1798 a new constitution, the first in the modern formal sense, the Staatsregeling voor het Bataafse Volk, written by a constitutional assembly, went into force, approved by the National Assembly. The Napoleonic Kingdom of Holland, a constitutional monarchy, was established by the Constitutie voor het Koninkrijk Holland on 7 August 1806. In 1810 the kingdom was annexed by the French Empire. After the French troops had been driven out by Russian Cossacks, the new independent state of the Netherlands, a principality, was established by the Constitution of 29 March 1814, the Grondwet voor de Verenigde Nederlanden. William VI of Orange, instated on 2 December 1813 as sovereign prince by acclamation, and only excepting, under the safeguard of a free constitution, assuring your freedom against possible future abuses, had first appointed a number of men of good standing as electors, and these approved the constitution, written by a commission headed by Gisbert Karel van Hogendorf. On 24 August 1815 William, since 16 March King William I of the Netherlands, having proclaimed himself king of the larger United Netherlands 6 days earlier, issued the first version of the current constitution, the Grondwet voor het Koninkrijk der Nederlanden or Loi Fondamental du Royaume des Pays-Bas, establishing the United Kingdom of the Netherlands, now expanding his realm with the territory of the present state of Belgium, which would again secede from it in 1830. It included a limited unentrenched Bill of Rights, with freedom of religion, the principle of habeas corpus, the right of petition and freedom of the press as its main points. In the Treaty of London of 1814 the Allies had ordered that the original Dutch state would devise the new constitution. It had been approved by the new States General of the Northern Netherlands, but rejected by the majority of appointed electors of the Southern Netherlands, as 126 however had indicated that they were against because of the freedom of religion, which was mandatory under the Treaty of Vienna that ordered the union of the Northern and the Southern Netherlands. Their votes, and those of the men having refused to vote, were added to the minority, and by this infamous Hollandic arithmetic, William felt justified to proclaim the new kingdom. Regarding the frame of government, the 1815 constitution did not diverge much from the situation during the Republic. The 110 members of House of Representatives of the States General were still appointed by the States Provincial, who themselves were filled with nobility members or appointed by the city councils, just like under the ancient regime. However, now also some rural delegates were appointed to all states provincial, and the city councils were appointed by electoral colleges, which were in turn elected by a select group of male citizens of good standing and paying a certain amount of taxes. So very indirectly there was a modicum of democracy introduced to the system. In all, the administration was very monarchical, with the king appointing for life the members of the Senate. That mockingly was called the Menagerie du Roi. In 1840, when a new revision was made necessary by the independence of Belgium, a first step to a more parliamentary system was taken by the introduction of penal ministerial responsibility. The Constitution as it was revised on the 11th of October 1848 is often described as the original of the version still in force today. Under pressure from the revolutions of 1848 in surrounding countries, King William II accepted the introduction of full ministerial responsibility in the Constitution, leading to a system of parliamentary democracy, with the House of Representatives directly elected by the voters within a system of single-winner electoral districts. Parliament was accorded the right to amend government law proposals and to hold investigative hearings. The States Provincial, themselves elected by the voter, appointed by majorities for each province the members of the Senate from a select group of upper-class citizens. A commission chaired by Johann Thorbecke was appointed to draft the new proposed constitution, which was finished on the 19th of June. Suffrage was enlarged, as was the Bill of Rights, with the freedom of assembly, the privacy of correspondence, freedom of ecclesiastical organization and the freedom of education. In 1884 there was a minor revision. In 1887 the census suffrage system was replaced by one based on minimal wealth and education, which allowed an ever-growing percentage of the male population to be given the right to vote. Therefore this provision was at the time nicknamed the Kutch-Ouch Article. The election interval for the House of Representatives was changed from 2 to 4 years. Eligibility for the Senate was broadened. Any penal measure not based on formal law was prohibited. In 1917, like in 1848, influenced by the tense international situation, manhood suffrage was introduced combined with a system of proportional representation to elect the House of Representatives, the States Provincial and the municipality councils. The Senate continued to be elected by the States Provincial, but now also employing a system of proportional representation, no longer by majorities per province. The Christian Democrat parties allowed manhood suffrage in exchange for a complete constitutional equality in state funding between public and denominational schools, ending the bitter school struggle, which had antagonized Dutch society for 3 generations. By the revision of 1922, universal suffrage was explicitly adopted in the Constitution, after it had already been introduced by law in 1919. Each 3 years half of the members of the Senate were to be elected by the States Provincial for a period of 6 years, within a system of proportional representation. In 1938 there was a minor revision, introducing some elements of the then fashionable corporatism by giving a constitutional base to public bodies regulating sectors of the economy. A proposal to make it possible to impeach revolutionary members of representative bodies, directed against communists and fascists, failed to get a 2/3 majority. After the Second World War in 1946, a revision failed attempting to simplify the revisional procedure. However, a change was accepted allowing to send conscripts to the colonial war in the Dutch East Indies. In the revision of 1948, a complete new chapter was added to facilitate the incorporation of the new state of Indonesia within the kingdom. Soon it would become irrelevant as Indonesia severed all ties with the Netherlands in 1954. In 1953, new articles were introduced concerning international relations, as the Netherlands was abandoning its old policy of strict neutrality. In the revision of 1956, the constitution was changed to accommodate the full independence of Indonesia. The number of members of the House of Representatives members was brought up to 150, of Senate members to 75. The revision of 1963 accommodated the loss of Dutch New Guinea to Indonesia. The voting age was lowered from 23 to 21. In 1972 there was a minor revision. The main change was a lowering of the voting age to 18. In 1983 the constitution was almost entirely rewritten. Many articles were abolished. Social rights were included. Most articles were reformulated using a new uniform legal terminology and their sequence was changed. The Bill of Rights was expanded with a prohibition of discrimination, a prohibition of the death penalty, a general freedom of expression, the freedom of demonstration and a general right to privacy. In 1987 there was a minor revision. In the revision of 1995, the introduction of a professional army, replacing the conscript army, was regulated. In the revision of 1999, a proposal to introduce an advisory referendum was rejected by the Senate. After a minor revision in 2002, the last changes were made in 2005. A proposal to introduce an elected mayor was rejected by the Senate. Unwritten constitutional law. Some of the most basic fundamental laws in the Dutch constitutional system are not explicitly expressed in the written constitution. These include the rule that the Dutch monarch cannot dissolve the House of Representatives more than once because of a conflict over a single political issue, and that the Senate shall never block legislation for mere party politics, so that coalition governments do not need a majority in the Senate. The unwritten laws are most influential when a cabinet is formed. The procedure is not regulated by the Constitution but based on tradition and more recently on regulations established by the House of Representatives. At the eve of the elections, the sitting cabinet offers its resignation to the monarch, who takes it into consideration. The cabinet is now demissionary. After the elections, the king consults his advisers. The chairman of the House of Representatives then appoints an informateur, who explores the possibilities of a coalition cabinet. Because of the Dutch multi-party system, no political party has ever obtained a majority by itself. On the basis of the information process, the chairman then appoints a formateur, who literally forms the government by negotiating an coalition agreement between the coalition parties and the division of the ministerial posts between the parties. He also meets with candidate ministers and often becomes prime minister himself. The king then dismisses the sitting cabinet and appoints the new one. If the procedure turns out to be problematic, the House can ask the king to play a role in the formation process. In common law systems, these rules would not be seen as laws but as mere legal conventions, as they cannot be upheld by judges. Within the Dutch civil law system, however, they are part of the more extended Dutch-German legal concept of the Recht. The total, legal, normative structure, be it written or unwritten, so that they have full normative force. Indeed, that force is much larger than with written constitutional rules. Any breach of the unwritten rules would cause an immediate constitutional crisis.